All right, I think we are good to go. Good morning. It's Bernard Nomberg with another weekly episode of Nomberg Law Live. Hope everybody's doing well out there. It is a Tuesday morning, 10 o'clock, and we are in is this the third week of the month? That's crazy. But I've got my buddy from New Orleans, Brent Cueria, is there. Good morning, Brent. How are you doing, my friend?
Hey, Bernard, fine. How you doing?
I'm doing well, thank you, and I appreciate you making some time this morning for us to have a little chat.
Yeah,
Talk to
glad to
me.
be here.
Absolutely, absolutely. Talk to us a little bit before we get into the meat of this. Talk to us a little bit about yourself, Brent, and about your practice in New Orleans.
Sure. Well, I've been a lawyer about 32 years now. We are based out of New Orleans, and we have a satellite office in St. Mary Parish, which is an outlying parish near the Gulf of Mexico, and that's where we get a lot of Jones Act and maritime clients from. And it's just a nice place to practice. And we have four lawyers in our firm. I have one lawyer who's of counsel, and then two other lawyers who actually have their own practice that work within our firm. So we stay pretty busy, and we have been doing this a long time and just having a good time in New Orleans.
Excellent, excellent. Well, when you're not playing guitar or traveling abroad, talk to us when you have time. I know you guys are very busy doing the similar type work that we do. We don't handle Jones Act or maritime, but it's the same mindset. Folks who get hurt on the job. And for people who don't know what those types of cases are, give us a little tutorial. What is maritime law? What is Jones Act? What do those things mean?
Sure. Well, I mean, I guess a maritime practice and a Jones Act practice is real similar to your workers' compensation practice, except that all of our clients are injured on water or vessels navigable waterways. So I guess maritime law is an old body of law. It started back it's in the common law from England for centuries when all these guys were on boats, and it provides a remedy for somebody who's injured on the sea. Most of the clients that we see in this office are Jones Act clients, which are guys that are working on vessels and contributing to a vessel, to the mission of the vessel. A lot of guys are working in the Gulf of Mexico doing oil and gas work, so we see a lot of clients on supply boats or jackup rigs or all these special purpose vessels you see to produce oil and gas in the Gulf.
And
And
Brent, these people you're referring to, who are their employers in general? What type of industry?
uh, Usually it's oil service companies that supply boats. You'll have companies that provide all the boats, bring equipment to and fro from the offshore platforms. Their employers will be actually the oil companies and the companies that own the platforms. And because in the Gulf of Mexico, when you have somebody who works on a fixed platform, that person's not going to be a Jones Act seaman. They'll be limited to either workers' comp or longshore and harbor work. But if you have clients working on movable drilling rigs, those are classified as vessels because they move around. And so those people can bring Jones Act claims, and their employers will be the oil companies or the operating companies of these jackup rigs.
So is the big difference here between, say, state work comp law and someone who gets injured, if they get injured on the water, it's a moving vessel as opposed to a fixed uh, something that doesn't move but happens to be in the water. Is that the differential, or am I not clear on that?
It's pretty close. It's kind of a gray area, but I mean, essentially, if you have a client that is a deckhand or a captain on a supply boat, then
Hmm.
they're going to meet the status requirement of the Jones. They're going to be a crew member, and they're obviously part of the crew. Sometimes you get these gray area cases where you have clients working on jackup rigs moving in a plug and abandon field, for example, from platform to platform where they're trying to close platforms. And they'll do some of their work on the jackup rig, some of their work on the platform, and then there's a test that you have to meet the status requirement to be a seaman. So some of those cases, and you have to contribute to the mission of the vessel. You have to have some connection to the vessel or fleet of vessel, and you have to spend at least 30% of your time in furtherance of the mission. So that's to get past summary judgment. You don't
Right.
really have to deal with that if you have a straight case where you have an engineer who's assigned to that vessel or a captain who's working on that vessel, and they're not working on any other vessels, it makes it an easy connection.
And Brent, let me give you a couple of examples, and maybe you can kind of educate us a little bit. Let's say that I am a fisherman and I work on the Cueria boat, and we go out fishing for lobsters, and I get injured while I'm a crewman doing my job. I slice open my hand on a hook or something. What type of case could that be?
So you'd be a Jones Act seaman because you would be assigned to that vessel, and you would have, unlike a land-based worker, you would not be limited only to workers' comp. You would be able to make a claim against your employer under the Jones Act. So you would, under the general maritime law, if you were injured because of an unseaworthy condition of the vessel, let's say that there was a hook that came undone that was defective, and that caused, and a net fell on you, and it caused you to injure your hand, you would have a claim against the vessel for unseaworthiness because the employer or the owner of the vessel has a non-delegable duty to provide you a safe place to work. Sort of like land-based workers have to have safe places too. But in addition to that, you would have the right to sue your employer under the Jones Act, which means you can sue them for negligence, whereas in workers' comp, you can't. You're limited to comp. Okay? Right. So you could sue them for failing to provide you a safe place to work, or having a captain or a crew that was inexperienced or improperly trained. All the same kind of allegations you'd see in a land-based case, except that it happened on a boat and that you still have the right. I mean, they created the Jones Act around 1920, and it kind of paralleled the FELA, the railroad workers who had the right to be able to sue their employers. It's really an embodiment of that law.
And are these cases and these acts, these laws we're talking about, are these federal or state laws?
It can be either. The federal court, as you know, is a court of limited jurisdiction, and admiralty jurisdiction is one of the courts. So you can bring your Jones Act cases in federal court. And for many years, I did a lot of cases in federal court. But we also have the right under what's called the Savings to Suitors Clause to file a Jones Act or a maritime case in state court. So what that means is the state court would actually apply the maritime law, and they would supplement state law where there was no conflict. So that way, and sometimes I make a strategic plan. Do I want to be in federal court or state court, depending upon if you were a fisherman from Alabama, for example, on a crew boat injured in Louisiana waters, I could file suit in federal court. They would have jurisdiction. If they weren't in Louisiana waters, I might have to file suit in federal court in Alabama. But if, for example, you were injured in some waters, adjacent waters to Orleans Parish or St. Mary Parish, or a parish that I would want to be in state court, then I could file the case in state court. And there's different reasons why I would want to do that. In state court, I don't have to have a unanimous jury. I get 9 out of 12 and I win the case. In federal court, I have to have a unanimous jury to win the case. There's some other interesting things.
So many questions. So many questions.
It's like a puzzle in the beginning. I always it's like a football game. It's where do I want to play, and so I get to decide. And and in federal court, I can decide if I want to make it a judge trial or a jury trial. They have the federal rule 9H, which gives me the option to make it a bench. Some cases I might want a bench trial as opposed to a jury trial. In state court, I usually would like a jury. So it makes it interesting in the beginning of a case.
Do the damages that you can pursue, do those change whether you're in state or federal, or because you're following the Jones Act laws, do the damages stay the same regardless of which court you're in?
Pretty much going to have the same damages. I mean, a seaman, just like anybody in a rear-end car accident, is going to get their pain and suffering, their lost wages, and those type of damages. Unlike, I guess, in your workers' comp practice, the equivalent is a seaman gets maintenance and cure. And so the maintenance is the comp part. And really, it's the illness or injury occurs on the vessel. It's almost like strict liability on the maintenance. They're going to get paid that, just like on a comp case in many instances, except that the maintenance is generally it's only like $35 a day. It's not that much. And then the cure is the medical bills, which the employer ship owner has to pay until there's maximum medical improvement.
Very
Unlike a comp case, the pendulum changes every few years. But right now, and if an employer or Jones Act employer fails to pay maintenance and cure and is found to be wanton and reckless, then the Jones Act employer can sue them for punitive damages and for the additional pain and suffering they incur if they, for example, delay their medical treatment or don't approve medical treatment. So that's a good remedy, because for when I first started practicing, the first 10 years of my maritime practice, we could get punitive damages. They didn't approve maintenance and cure. And then then the courts didn't allow that for a number of years. But for the past 10 years or so, they've allowed it. What that's done is all the employers are actually, because they don't want to have a punitive damage claim, so they approve all the necessary treatment that a client needs. So it works out really good now.
So many decisions and strategies to think about, but I know that I hear it in your voice, your passion for this type of work. I know you've been doing it for quite a while. And for those of you just joining us, talking with Brent Cueria out of New Orleans, we're talking about injuries on the water, whether they're work-based or it makes a big difference, Jones Act versus the maritime laws, and we're just kind of plowing through a little bit of the differences and how it works. But Brent, I want to go back to our example. Let's say I'm still that crewman and a fish comes flying out of the water, a sailfish, and punctures my hand and injures me that way. Obviously, it's not the boat it being defective, but what's the nuance? What's the difference here?
Probably that would be a really difficult Jones Act case, because I don't think it's foreseeable unless that's something that happens a lot in that particular type of fishing, and then perhaps the boat's supposed to have some type of netting to protect the crew members. I'm not aware of anything like that. But let's assume that there was, let's say I didn't have there's no standards or no experts that would say that was negligence from the employer, then that injured seaman would be entitled to his maintenance and cure. And so they would have to pay his maintenance when he was not able to work, and then all his medical bills. I don't hear in those fact situations any blatant unseaworthy condition or any negligence, but who knows? So
let's take it outside of being a crewman. Let's say I'm a lawyer from Alabama, and I am down in the New Orleans area, but we're out on a boat inspecting a boat that's defective, the claims in my lawsuit that I'm pursuing. I'm out on the boat and we're doing an inspection of the boat about a particular area that's defective because I represent an injured person who happened to be on the boat at the time. We're going to pursue a claim or a case against the boat owner, etc. But while I'm on the boat, I slip and fall and fracture my leg.
Now, you're not a seaman.
Right.
Yep. So you're not a seaman because you're not assigned to the vessel. So you certainly would not have a Jones Act claim.
No. I think
that,
I've got. Go ahead.
You probably have a general maritime claim for just ordinary negligence if they were negligent. If you didn't sign a release to go do an inspection, because many of the companies nowadays make us sign releases, which may or may not be valid. It's often hard to release something that has not occurred in the future.
Right. And that's
you would not have a Jones Act.
Is that just to step on board of the boat? You have to likely sign that release?
Yeah, a lot of times they do, but a lot of times they're not even valid. So it's kind of like if you've seen asbestos settlements, they will try to get you to people to sign releases for things, diseases, latent diseases that have not occurred and would occur 20 years from now. Those are not generally upheld by the courts. So, I mean, most releases, you can't release prospectively something that's not occurred. So, they do try that sometimes. And then sometimes we have motion practice about, can they even do that,
Uh-huh. Well, no, I can see that. I suspect in my scenario, I've got an Alabama work comp case because I'm on the job at the time for my employer when I get hurt. But I'm just kind of thinking, are there additional legal theories that can be pursued either in state or federal court in Louisiana because of this.
Well, you'd have a third party. I wasn't even thinking about the comp claim for you, I'm thinking about the third party claim, and you would have a third party claim against the vessel owner or charter or whoever was in control. It's no different than if you had slipped and fell in a casino, except this would be an admiralty claim. Would not be a Jones Act claim.
Okay. Well, I want to welcome, we've got some folks who are here. I've got William in Georgia I've got a question for you, Brent. And the question is, what if in the scenarios that we've been talking about, does it make a difference if the boat itself is attached to a dock as opposed to being out in the water itself? Does that make any difference in these scenarios?
It's got to be a vessel in navigation. That's just a term of art, meaning that no, if the vessel, like the casino boats in Mississippi that are permanently moored to the dock and are not able to move, they lose their vessel status. But if it's just a boat that's able to move and is capable of moving and just happens to be at the dock, and let's say a seaman it gets injured on a gangway coming from the vessel to the dock, then he could have a Jones Act claim. So no, it doesn't matter if it's moored, as long as it's not permanently moored or taken out of navigation.
I see. Okay, well, that makes sense. What about, Brent, a scenario, and I realize I'm just kind of throwing all these different made-up scenarios to you, but I find it so interesting because this is something I know nothing about, and I appreciate you teaching me and whoever's watching our video, either live or later on. When you pursue these claims under Maritime Law or Jones Act, whatever it may be, as part of your damages claim, is there any provision under those laws, like in Alabama state court, you can pursue your claim for lifetime medical care? That can be something that if you try your case or you settle it with those provisions, or you can settle out your future medical care rights. Are there any provisions under those laws that we're talking about that deal with future medical care?
I think an employer, Jones Act employer, is only liable for maintenance and cure up to the point of maximum medical improvement. Now, the cure, I guess if I had a client that was going to have lifetime medical expenses and needs, then I would hire a life care planner to come in and testify, and I present that evidence to the court along with an economist. Because generally the employer will only pay maintenance and cure up to maximum medical improvement. But we could still prove additional damages, but there's no lifetime formula for like you have in Alabama comp.
Well, that's what I was going to ask you. What if it's a brain injured claim? Somebody who's going to need that medical care for however long that their life expectancy is.
Then I would present that evidence, and I would hire a life care planner, and I would hire an economist. Typically the playbook for these maritime cases is I have a maritime expert, kind of like it's no different than a slip and fall or a premises expert on land. Sometimes I have guys that are injured, slip and falls, or cranes falling on them, failing to evacuate, and then I have, besides my liability expert, I'll have vocational expert or life care planner, and then an economist. So I would prove that future medical through those experts and my doctor.
Interesting. Well, Brent, what kind of defenses are there that you've had to hurdle over? What kind of things are you seeing?
Well, typically they like to try to deny maintenance and cure under the McCorpin defense, which is when a lot of these guys, because most of these guys that work offshore and on boats, they're kind of rough and tumble guys, and they've been around the block, and they, just the nature of the work, boats are moving, it's dirty, there's grease all over the place, and lines and everything. So these guys a lot of them have had a few bumps and bruises. So when they go to take the pre-employment application to work for a company, if they've had any kind of back injury and if they're not completely honest about it, then they'll try to deny that future compensation. Well, they try to deny the maintenance and cure. The interesting part about that is even if they're found to have willfully concealed, for example, a prior back injury, they may forfeit their maintenance and cure, but that doesn't mean they can't still present the same claim for medical bills and pain and suffering under the Jones Act negligence claim. They don't lose it. They just potentially forfeit maintenance and cure.
Well, Brent, that also sounds like it goes potentially could affect their credibility in front of the trier of court for a misrepresentation.
That's a big part of it. I mean, these cases are no different than any other civil case. Credibility is one of the most important things, and that's what the court and the jury is going to be looking at in most of these cases.
Well, Brent, I know that you have recently written a book that addresses a lot of this. Let's talk about your book, if you don't mind. Do you have
Sure.
Do you have a copy of it handy you can show us?
Yeah, I do. I wrote a book right here, and mostly give it to my clients. It's called Napoleon's Code. It's just a guide to personal injury and maritime law in Louisiana. And I don't think it's on Amazon or anything like that I know of right now, but I mostly just give it to my clients, and enjoyed writing it. I'm in Max Law and all the guys are writing books in our group, so I wrote a book. So
Well, I'm sure it's very educational. If folks think that they've got a case or they want to get a copy of your book or reach out to your firm, what's the best contact information for you guys?
William's in here with me. I think they're putting it on the website.
Yeah, we'll be putting a PDF on the website, and also we sell it on lulu.com.
Yeah, I guess we sell it on lulu.com, and then we're putting it on our website. So we'll be having a PDF version to email to people. So if anybody wants it, they can. Is it on the website right now?
Not yet, but it'll be up
in the next month or so. It'll be on the website.
Okay. In our show notes, in the comments section, I put the link to your website, to CueriaLaw.com. So, folks, if you want to reach out to Brent or his firm, just click on that and it'll get you to him. I'm also going to put a link to your Facebook, the firm's Facebook page. So it'll be another resource for you guys to be able to reach out to Brent and the folks at the firm. Now, Brent, when folks go to, if they call you and they feel like either they or a family member has a potential claim, what information do you need for them to have at the time they're calling, as opposed to double work and having to call you back again?
On a Jones Act claim you're talking about?
Yeah, either Jones Act, anytime a maritime, any kind of case they feel like your firm can help them with.
Yeah, so personal injury cases, like auto cases and all, my staff will take the basic information, and on all the incoming calls, my staff will take the basic information. On a Jones Act case, as you can tell, they're all factually intensive as to whether, I really have to meet with the client and spend a lot of time because these are expensive cases to prosecute, so I have to make a good decision going into it. And I want to make sure that I can do a good job for the client, and I want to make sure they're assigned to a vessel, that I can prove negligence, make sure that the client is, that I can find out what the injuries are, make sure they're large enough injuries to justify the expense and time involved in a case. I spend a lot of time talking to a client, meet with them in person for most Jones Act cases, just to make sure I can meet all the requirements that I need, the vessel status, seaman status, and then I help them arrange medical treatment if they need it, because most of these companies will try to set them up with a company doctor, which most of those doctors tend to be write reports that are in favor of companies. They get all their business from these offshore companies. You know how it works. Yeah. So I let the client know they're entitled to choose their own doctor, and I make them aware of that and kind of get them on the right path to looking into their own doctor.
Brent, it really sounds like you and the firm have a real personal touch when it comes to dealing with these cases, because I know you have to screen them so carefully and to educate the people as they're going through a very stressful time as well.
Yeah, you really do. It makes a big difference. I mean, I get phone calls on some of what I'll call marginal Jones Act cases, and I have to tell these clients that they have to be very careful because some of these guys are making $80,000, $100,000 a year and have a good job, and if they're going to just, potentially make a claim over a cut finger or a cut hand where they're going to get, less than $20,000 recovery, it's not worth them jeopardizing their job. Or if I even have somebody who's got a potentially good injury, but maybe the liability is very poor, have to educate them and make sure that they're making the right choice and some of these cases are not even so clear. Some cases are not strict Jones Act cases. Sometimes I have general maritime cases with third-party claims, or I have a combination Jones Act client who's making, I might have a Jones Act client who's a crew member of a vessel, who's got a claim against the captain for not maneuvering the vessel properly, for example, on a vessel transfer, but I could have a general maritime claim against the crane operator and the platform for not putting the basket down properly. So sometimes we have multiple claims going. It's an interesting practice.
Are there any type of anti-retaliation clauses or laws that also apply to these type of cases?
Yes, there are. So if most of the Jones Act claims that I have handled, many of them people were not continuing to work, so there was no retaliation because these guys were not able to keep working anyway. But there are some retaliation provisions if you make a claim and they retaliate, then there's some provisions.
Brent, we're getting close to the end of our discussion, and I sure appreciate what your expertise in educating us so far. I want to leave you or give you the last word about these type of cases, and I want to ask you this: what is your recommendation that if somebody gets hurt on the job on one of these vessels in the water or a platform, whatever it may be, what steps should they take to properly inform or educate or move forward with a claim that they want to make sure that their rights are protected?
Well, I think it's important that if somebody's injured, that they fill out an incident report and they make sure that they tell their employer or the medic on the platform, wherever they are, how they got injured and what parts of their body they're injured. Because I've handled a number of cases where the medics on the offshore platforms, they just brush these guys off and they don't fill out incident reports. These guys get hurt. They end their hitch and they go home and they realize that they're injured and they go see a doctor. They can't go back to work, but then it's tougher for me because I don't have an incident report and I have to go back and reconstruct witnesses. And if I had it all in the incident report, it would be much easier. It makes it a more credible claim to have an incident report. It's just like a land-based claim. But I think that's important. And then also if somebody's injured, to go see a lawyer, talk about their rights, because there's a lot of different areas to consider in these maritime cases about whether they're longshoremen or Jones Act, what type of claims they have, and how it's going to affect their job and what their rights are in the future. So I think it's important to maybe talk to a lawyer and get some advice on seeing that doctor if they're injured. Not just a company doctor, they're entitled to their own doctor.
Well, Brent, such great information. And guys, whether you're watching now or later on, you're hearing it from one of the best, based out of New Orleans, Cueria Law Firm. Brent, I really appreciate your time, your expertise, and sharing some of that with us today.
Yeah, thanks for having us, Bernard. It's a good time. I appreciate it.
Absolutely. And guys,
take care.
For those of you, that'll conclude us for today. And as we try to do each Tuesday at 10 o'clock, NOMBERG Law Live each week, trying to bring interesting conversations with people in their area of expertise. And Brent certainly fits the bill this week. You guys take care, and we'll see you next week. Bye-bye.
See you, Bernard.